When we think of a criminal trial, our minds usually jump to those intense, dramatic courtroom scenes from the movies. But what if I told you the legal system has a kind of express lane? The law is pretty smart. It gets that a simple shoplifting case shouldn't have to go through the same long, complicated process as a murder trial. A one-size-fits-all approach just doesn't cut it when it comes to justice. So today we're diving into the two main tracks that every criminal case follows: summons cases and warrant cases.
I mean, just think about it for a second. On one hand, you've got a minor theft. On the other, an armed robbery. Does it really make any sense for our courts to spend the same amount of time, resources, and legal energy on both? The answer seems pretty obvious, doesn't it?
Exactly. The answer is a huge no. And this is where you can really see the logic built into our legal framework. The law cleverly splits the path to justice into two, making sure the process always fits the seriousness of the crime. This is the crucial difference we're breaking down today: the difference between a summons case and a warrant case.
Okay, so here's our roadmap. First, we're going to get to know these two paths. Then we'll look at their official legal definitions and compare their biggest differences side by side. After that, we'll do a step-by-step walkthrough of a summons case trial to see how it works in the real world. We'll even cover some special powers a judge has to switch tracks mid-trial, and then we'll wrap it all up with the key takeaways.
You can think of this as the very first fork in the road a case hits after a crime is reported. The way an offense is classified right at the start sets the tone for the entire legal journey that follows, from how the trial starts to the possible ways it can end. So, what is a summons case, really? Well, the law itself, in Section 21BH, defines it in a surprisingly simple way. It's any case that isn't a warrant case. To put it plainly, these are for the less serious crimes. We're talking about offenses where the punishment is 2 years in jail or less. This is the system's streamlined, fast-track process.
And on the other path, we have the warrant case. Here, under Section 21Y, the law is all about the severity of the punishment. If a crime could lead to the death penalty, life in prison, or more than 2 years behind bars, it's automatically a warrant case. This is the path for serious crimes that demand a much more thorough and careful trial.
So, that's the magic number: 2 years. That one simple threshold changes absolutely everything that comes next. Now that we've got the definitions down, let's look at how that single difference creates two totally different journeys through the court system. All right, this is where things get really interesting and practical. Let's put these two case types head to head and see just how different their procedures are. This is absolutely key to understanding what this classification means in the real world.
This table really shows you the two different worlds these cases live in. Let's zone in on a few huge ones. First, look at formal charge. In a summons case, you don't need one. It's more informal, designed to be quick. But in a warrant case, framing a formal, written charge is mandatory. It's a very serious step because the stakes are so much higher. Now check out cross-examination. In a summons case, the accused gets one shot. But in a warrant case, they get two. One before the charge is framed and one after. That's a massive protection for the accused. And finally, the outcome. A summons case ends with either a conviction or an acquittal. But a warrant case has a third possibility: discharge. That means the judge can end the case early if they decide there isn't enough evidence to even bother with a full trial. See, every single difference is there to perfectly balance speed with fairness.
Okay, so let's actually walk down one of these paths. We're going to do a deep dive into the procedure for a summons case, step by step, just as it's laid out in Sections 274 to 282 of the Criminal Procedure Code. This is the express lane we were talking about. So it all kicks off with Section 274. The accused shows up in court, and the magistrate just tells them what they're being accused of and asks if they plead guilty. Notice, there's no formal, complicated written charge. And there's a really important update to this law. If the magistrate thinks the accusation is totally baseless from the get-go, they can discharge the accused right then and there. It's a fantastic filter to stop pointless trials before they even start. Now, if the accused says, "Yep, I did it," Section 275 kicks in. The magistrate can just record that guilty plea and convict them on the spot. It's that simple. And for really minor petty cases, Section 276 makes it even easier. The accused doesn't even have to come to court. They can just send a letter pleading guilty and include the fine. It's all about efficiency. But what if the accused pleads not guilty? Well, that's when a real trial begins. Under Section 277, the prosecution gets to present all its evidence and witnesses. Then, the defense gets its turn to challenge everything and present its own side of the story. This is the heart of the legal process, the back-and-forth battle of evidence. So, after hearing everything from both sides, the magistrate, under Section 278, makes the final call. The outcome can only be one of two things. Either the accused is found not guilty and is acquitted, or they're found guilty and convicted. But there's a really important legal principle that goes along with this step that we have to talk about.
This is a critical point from the Supreme Court. Just because someone pleads guilty, it doesn't mean they automatically get a lighter sentence. The court was very clear. You can't use a guilty plea as a bargaining chip. The idea of trading a confession for a guaranteed lighter sentence goes against public policy. The punishment has to fit the crime, not the plea.
The law is also practical about real-world situations. For example, under Section 279, if the person who filed the complaint just doesn't show up to court, the magistrate can acquit the accused. And similarly, under Section 280, if the complainant decides they want to withdraw the case, they can ask the court for permission, which would also result in an acquittal.
Now, just when you think the path for a trial is set in stone, the law throws in a twist. It gives the court some pretty special powers, tools a magistrate can use to change the course of a trial if justice requires it.
Think of Section 281 as a stop button for the trial. The magistrate can halt everything, but when they press that button is crucial. If they stop the trial after the main witnesses have testified, it results in an acquittal. The case is over, done for good. But if they stop it early on, it results in a discharge, which is different because a discharged case can sometimes be brought back to life later.
And here it is, maybe the most powerful tool of all. Under Section 282, a court can completely switch the tracks. It can take a case that started on the fast, simple summons path and convert it into the more serious, detailed warrant path.
Now, this is really important. A judge can't just do this on a whim. Section 282 lays out strict rules. First, the crime has to be punishable by more than 6 months in jail. And second, and most importantly, the judge must believe that making the switch is truly in the interest of justice. That means they look at everything, the nature of the crime, the evidence that's come up, and decide that the simpler summons procedure just isn't enough to guarantee a fair trial.
All right, we have covered a ton of ground, from the basic definitions to the nitty-gritty of a trial and even a court's special powers. So, let's boil all of this down to the most important ideas you should remember.
When it comes right down to it, the whole philosophy is this simple. Summons cases are all about speed and simplicity for smaller crimes. Warrant cases are all about seriousness and caution for major crimes. The entire system is a balancing act, trying to be both efficient and incredibly careful at the same time.
So I'll leave you with this to think about. On paper, this two-path system is a brilliant idea for balancing speed with fairness. But does it always work in the real world? With our courts facing huge backlogs and increasingly complex cases, is this elegant solution really enough to deliver the justice people deserve? That's definitely something worth considering. Thanks for tuning in.